Why should I give probation to a gentleman who may have violated the bond? Why should I think he's not going to violate probation in the same fashion? And because a police officer is involved, it makes me think that maybe the bond involves another battery or something. Okay, Mr. Patterson, who would you like to take up? Oh, wait, is there someone sitting at the jail? Who is that says sovcit that looks like he might have an officer uniform?
Your Honor, it would appear that in this matter, a subpoena was issued for Officer Sarchett in the Brandon Branscombe matter. I'm not sure if the court wishes to take that one up at this time or not.
Yes, yes, we should do that. I'm sorry, officer, to make you wait that long. Everybody's backed up here today trying to get it on the docket. Okay, so this is for Samantha Slater.
Your Honor, the state understands that Ms. Slater is also a subpoenaed witness in this case.
For Branscombe. Okay. We are on the record in 2025 CR 185, State of Kansas versus Brandon Lee Branscombe. Jared Regier for the state, Darren Patterson for the defendant. Please start your audio and video, and please find a spot to sit and not be moving around, sir. Can you hear us, Mr. Branscombe?
Yes, Your Honor.
All right, this is a motion to revoke or modify bond. The defendant is alleged to have had contact with a Danielle Erskine pursuant to Newton PD number 25-1121. And that would be in violation of the defendant's bond. I see we do have subpoenaed witnesses Samantha Slater and Officer Brett Sarchett of Newton Police Department. And I understand that Sarah Recheck, agent of Owens Bail Bonding Company, as well as the defendant and his attorney, were notified of the motion to revoke or modify. Mr. Florio is here for Simpson. Do we have anyone here from Owens for Branscombe? All right, Mr. Regier, do you wish to proceed on the motion?
The state is prepared to proceed, Your Honor. However, this does appear to be a case where the information was originally filed by my colleague, Ms. Norris. I understand there may be certain plea negotiations in this matter, so the state would respectfully inquire of counsel for the defense whether what the status of those are.
I'll accept.
And Judge, I would tell the court that I have discussed with Ms. Norris a way to resolve the case without taking up the motion. Based upon that, I believe my client is going to enter a plea of no contest.
Yes.
So you reached an agreement with the state to set aside the motion, but no one canceled the subpoenas. I suppose that's not all bad in case this no contest plea doesn't work out, but it would have been nice to let the officers know. Okay, so before I let you go, since you've waited this long, folks, if you don't mind just bearing with us a little longer. Mr. Branscombe, I'm told you're going to plead no contest to domestic battery, knowing or recklessly causing bodily harm to a family member or person in a dating relationship in Butler County, Kansas on April 16th of 2025. Do you plead no contest to that, or how do you wish to plead?
That's if I understand correctly, that's the domestic battery, a misdemeanor?
That is a misdemeanor class B, alleging that on or about the 16th day of April 2025 in Butler County, Kansas, Brandon Lee Branscombe did knowingly or recklessly cause bodily harm to another person, to wit, Danielle Marie Erskine, a person with whom the offender is involved or has been involved in a dating relationship or a family or household member, as defined by subsection E in violation of KSA 21-5414A1C1A, domestic battery class B person misdemeanor. How do you plead to that?
No contest.
By pleading no contest, you mean you're not admitting that you did this, but you don't want to deny it and take it to trial?
Yes, Your Honor.
Is anyone making you enter this plea today by threats or promises other than your plea agreement?
No, Your Honor.
Do you understand that with this plea, you'll most likely be found guilty,
Yes, Your Honor.
having waived your right to a trial and not able to appeal that conviction?
Yes, Your Honor.
All right, Mr. Regier, you have a factual basis to support this no contest plea?
Yes, Your Honor. Pursuant to the information, count one alleges that, quote, on or about the 16th day of April 2025 in Butler County, Kansas, the defendant Brandon Lee Branscombe did knowingly or recklessly cause bodily harm to another person who is identified as the victim in this case, a person with whom the offender is involved or has been involved in a dating relationship or a family or household member, as defined in subsection E. Were this case proceed to trial, the state's evidence would show the same. Additionally, the affidavit in this case does appear to refer to a past domestic violence disturbance at a location in Whitewater, Kansas. The state's understanding is that is within Butler County boundaries, as well as a reporting physical altercation between the defendant and the victim in this case.
You mentioned an affidavit. Well, the parties stipulate that if this were to go to trial, that affidavit would contain the facts that would be evidence in that trial.
Judge, for purposes of no contest plea, we have no objection to the court using the affidavit.
All right. All right, based on the affidavit, I find there is a factual basis to support the no contest plea, and I do find the defendant guilty. Now, folks, apparently you've worked something out where these folks that have come in from Newton are no longer needed. The Newton officer and Samantha Slater are no longer intended to be called as witnesses. Is that right?
Your Honor, the state's understanding is that upon successfully entering a plea to count one in this case, the state would move in exchange to withdraw the motion.
So are you no longer offering that there was a violation of the no contact order? You're no longer alleging that the defendant violated this court's order by having contact with Danielle Erkson?
Again, Your Honor, the terms of the plea negotiation was that upon successful entering the plea, the state would be moving to withdraw the motion revoking the bond in this case.
Well, you may be withdrawing the motion, but it seems like if we're going to proceed to sentencing, this court needs to know or would like to know if the defendant violated its orders, because that could have an effect on any probation that is made.
Judge, I guess I will speak up. That is part of the plea negotiations between Ms. Norris and I, that that issue would become moot and not part of the recommendations.
And that is the state's understanding of the negotiated plea agreement in this matter as well, Your Honor.
Well, plea agreement aside, it's troublesome that a man can be accused of domestic violence battery to a Danielle Erkson, and the court can order that he have no contact with her. And I'm supposed to just ignore that and proceed with plea agreement. That's troublesome. Well, let's hear what your plea agreement is, gentlemen. Sentencing recommendations from the state?
Yes, Your Honor. The state's understanding of the plea agreement in this case is that the state would be recommending a 6-month underlying sentence, the maximum sentence allowed by law for a Class B misdemeanor, as well as a 12 months reporting probation with court services, subject to all standard conditions consecutive to any other Butler County cases the defendant may be currently supervised on. The state would further be recommending all applicable costs and fees, that the court make a determination on the issue of attorney's fees, that the court not impose a fine, but that the court require a domestic violence offender assessment, and that the defendant be ordered to comply with all recommendations, that the court order no drugs or alcohol, and that the defendant be ordered to report today to court services.
Mr. Patterson?
Judge, we're asking the court to adopt the recommendations, including that the no contact order can be lifted upon him getting his domestic violence offender assessment and providing that to his probation officer.
And Your Honor, the state understands after further review of the file that that was also contemplated pursuant to the plea agreement in this case, Your Honor.
This Danielle Erskine, she's his sister, is that right?
Ex-wife, Judge,
Ex-wife.
or maybe common law wife now. They have kids in
Okay.
common.
The kids, okay, they have the kids in common. Okay,
10 years
what?
together. I'm
You have
sorry,
10
we have,
years? You and
we
this
have
woman
10
have
years.
10 years? Okay, and 3 kids?
Yes, ma'am.
When was the last time you saw her?
Oh, the day that I was arrested.
And was that is that in
Yeah.
Newton?
Yes, Your Honor.
All right, now, is this Officer Brett Sargent up here on the screen?
Yes, ma'am.
I suspect, though you weren't called by either of the parties, I suspect you have information about this defendant violating the court's order. Am I suspecting correctly?
Yes.
All right. I'm not going to put you under oath, but tell me just initially, informally, what the involvement is.
Judge, I guess I have to object because if we're going to get into a full-blown hearing, I mean, that's one thing, but not to have the ability to dispute it.
Fine. All right, fine. Raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Patterson, I don't know what you guys have going on that you're trying to get around the courts knowing that he's been out violating court orders.
And Judge, that's disputed. I'm going to tell the court that's disputed. My client would suggest that he's not the one who had invited this contact, that it was not him, so it's disputed, but that's why we've entered in plea negotiations to avoid the confrontation of a hearing.
Mr. Regier, what do you have to say about not wanting the court to know that there may have been a violation of a domestic battery bond or order that could affect, and why it's important now is it could affect his success on probation? Why should I give probation to a gentleman who may have violated the bond? Why should I think he's not going to violate probation in the same fashion? And because a police officer is involved, it makes me think that maybe the bond involves another battery or something. And that's important. So, Mr. Regier, what do you have to say for the state on this?
Your Honor, all I can tell the court is that the state did anticipate proceeding to a hearing today. However, the state is eager to reach a resolution in this case, and all I am aware of is the terms of the plea deal as negotiated between my colleague and counsel for the defense.
Ms. Slater, how are you involved in all of this? Are you an officer? Are you a family member?
No, I witnessed a verbal-ish altercation at the end of April in Newton.
All right. Well, I am going to tell you both, I'm not going to sentence him to probation until I know what's really going on here.
Judge, short of getting into a long trial, which is basically what we're talking about, I can tell the court my client was not arrested for a domestic violence event that day. Miss Erskine was, I understand, but my client was not.
Well, why can't Officer Sargent? Why do you have an objection to him saying that if that's all it was? I think there's more here than what you guys want me to know. And
I'm trying to avoid a long hearing, Judge, and get
Well,
the
that's
docket done. That's
fine.
exactly what that's a
Well,
purpose.
I'm all about avoiding long hearings that are unnecessary, but I am not going to shortchange somebody's physical well-being and put him on a probation if they've gone out and had another altercation while on bond when they were ordered not to have contact. I'm just not going to do that. So you guys can either have a hearing or I'll just order a sentence without probation. I'm not going to take a chance that somebody is going to get hurt again. And I'm not going to just ignore evidence that's right in my face. So you tell me, Mr. Regier, you're wanting me to do just that? You're wanting me to just ignore that he's apparently gotten into another domestic altercation with her when I ordered no contact? I'm supposed to ignore that? As officers of the court, can you genuinely recommend I do that?
Your Honor, may I request a brief 2-minute recess?
That would be fine.
Thank you, Your Honor.
Mr. Regier, if you're available, I'd like to reconvene. Mr. Regier, we are back on the record in 25 CR 185, State of Kansas versus Brandon Lee Branscombe, all parties as before. All right, folks, I set the bond as my responsibility. I set bonds. As my responsibility, I impose sentences. But before I proceed any further, I have to know what's really going on here. And both counsel have indicated that I shouldn't hear from this Officer Sergeant. But Officer Sergeant, do you have any information that this defendant violated the bond in this case, wherein I ordered that he have no contact with Danielle Erskine?
I do.
And what information do you have?
On April 24th of this year, we responded to a disturbance between a male and a female. Both the male and the female were located. I spoke with the witness who is here with us today. And she informed me that she watched a man driving a white SUV pull up into the alley near where she was parked. She saw the male exit the vehicle and begin screaming at a woman who was seated in the passenger seat. Upon locating both individuals, they were both identified, and they actually admitted that they had a no contact order in Butler County for a recent domestic violence arrest.
All right.
I also have another issue at hand. Last week, I reached out to the Butler County Sheriff's Office in hopes to get in contact with them to verify whether or not the bond conditions were still
I'm
in
going to
place.
object as hearsay, Judge, unless we have somebody from Butler County here.
I want to hear it. Go ahead.
I did that because I forwarded this case to the Butler County Sheriff's Office based on the information that the defendant had informed me of, that he had bond conditions. Last week, they were in contact again. We arrested.
Hang on. Who was back in contact again? The man and the woman?
Yes.
Okay.
So what he informed you earlier, that the last contact he had with her was the date he was arrested, and was untruthful.
Okay. All right. So the man and the woman in the truck, do you know who they were?
Is Brandon Branscombe and Danielle Erskine.
Okay. I didn't totally follow the Butler County thing. You contacted Butler County and told them what you had in Newton?
I tried to. I asked our dispatch to send a teletype, basically an email to the Butler County Sheriff's Office, to have one of their deputies reach out to me so I could verify whether or not the bond conditions were still in place.
And the result?
They did not reach back out to me. They did not call me.
Okay. All right. Okay. Ms. Slater, please raise your right hand. Solemnly swear the information and testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. Now, what can you tell me about anything that has to do with this Butler County case involving the defendant, Mr. Branscombe, and the victim, she's now determined to be the victim, Daniel Erskine. What can you tell me, if anything?
Sure. The only thing I can tell you is what I saw. I believe it was April 24th. I was in Newton for a work-related reason, but was sitting in a parking lot at the Dillons, and in front of me, a white SUV went into the alleyway that was in front of me, and I saw a gentleman exit the driver's side of the vehicle, shut the door, seemed flustered. I could not hear anything that was being said at all. I didn't have my windows rolled down or anything. I was just going off of visual. I could visually see that he was upset. He was yelling at the vehicle. And then after a little bit of time, I don't know exactly how much, he went to the passenger side. And then the passenger side door opened. He did not open it, but it did open. A woman got out. And then they were having a verbal altercation. They walked behind the vehicle, and then I saw her put her hand on his arm, kind of like a, hold on a second, come back kind of thing. And, he pulled his arm away, and he was still yelling at her. I couldn't really tell what her demeanor was or her reactions or anything. She did have her hands up a little bit, kind of like, whoa, hold on a second kind of thing. And then he continued to walk. He did pass the car. She did get into the driver's vehicle, or the driver's side of the vehicle. They were kind of following each other down the alleyway. There wasn't a whole lot going on at that point. I could still see that he was, agitated. He was still yelling at the vehicle. They did stop a couple times. I never saw her exit the vehicle again after she had got out of the passenger side. And then they had come to a street. I don't know Newton super well, but they did come to a street. The back hatch of the vehicle opened, and then it closed. I didn't see if anything was taken out or anything like that. And then they did continue to drive down the street. And then when they passed, I believe it's Main Street in Newton, I couldn't really see them after that. I saw her pull into the Little Caesars parking lot, and then I was kind of done with it at that point. I couldn't see anything anymore after that.
Did you report that at any time to law enforcement?
Yes, I called 911 just shortly after she had put her hand on his arm.
All right. Thank you.
Yep.
Officer Sargent, you're the one then that took the report and worked it?
There were, I believe, 3 of us working that specific case.
Have criminal charges been filed against either party, the Branscombe or Erskine? Do you know?
Yes, both of them went to jail that day.
Okay, and do you know if the prosecutor filed anything formally yet?
That I'm not sure.
Okay, all right. Okay, well, thank you both very much.
Judge,
Now,
I have a question for the officer.
all right, go ahead, please.
Officer, you said both of them went to jail that day. What were the charges against each of them that they were arrested on?
I believe Brandon was for driving on a suspended license, and the Danielle was for domestic battery.
Okay. Mr. Branscombe was not charged with domestic violence or arrested for domestic violence at that time. Is that correct?
Correct.
That's all I wanted to clear up, Judge.
And let me follow up. Okay, driving while suspended against Brandon, and what did you say against Danielle?
Was for domestic battery.
Okay, all right. Mr. Regier, you have any questions of either of these two?
No, Your Honor.
Did you have any for Miss Slater, Mr. Patterson? Okay. Well, folks, I am going to take this all under advisement. Mr. Branscombe, your attorney may not want you to talk right now. I don't know. He wants to talk, Mr. Patterson. Do you want to let him?
I will talk with Mr. Branscombe later, Judge.
All right. I am going to set over the sentencing on this. Now, the problem is I'll set the sentencing over 1 week. I know I'm gonna squeeze another one on you. Can we put that at 1:30? 1:30 by chance, Jen, on Wednesday, No, that can't do that either. Never mind. Let's put it 9 a.m. Monday, and the defendant must be present at the the Butler County Courthouse unless his bond is revoked. And at this time, I'm going to revoke his bond. You
And
need
Your
to
Honor,
turn.
Your Honor,
Mr.
as indicated on the record, the state has withdrawn its motion pursuant to
I
plea.
understand, and on my own motion. Mr. Branscombe, where are you at this moment?
I am waiting to enter into a inpatient facility. I've got my assessment and everything. My bed's
I didn't
waiting.
ask you what you were doing. I said, where are you? What town are you in?
I'm in Wichita, ma'am. Your Honor.
Wichita? All right. Are you in a residence? Are you in a treatment facility?
I am at a residence and I'm waiting for the court to be done with so I can go into my inpatient. They told me if you guys needed to speak with them on the court's behalf, you need to speak with them to verify that, for me to give you their number and they would verify that.
What are you going into treatment for?
For drugs and alcohol, Your Honor, I have an addiction problem and I mean, I need to get it taken care of.
So you couldn't even report to probation. You're not even ready to start reporting to probation. You're going into treatment.
Yes, I mean, yes, Your Honor, I feel that getting
How
myself
How about batter's intervention? Have you done an evaluation for that yet?
No, ma'am, I started mental health and med management through Prairie View in Newton. And I've been working with CCRT. I don't know if you're familiar with them, but they're out of Newton, Harvey County. And they have, I'm sorry, they also have the BIP program there at their location.
Okay, so you violate bond. You work out this nifty plea agreement with the prosecutor that you don't have to face any consequences for not only violating bond, but going out and getting into a confrontation with the victim. And then instead of reporting to probation, you're telling me, or going to jail, as I could order you, you're telling me, well, I went out and I got myself into an alcohol and drug treatment program. Although the issue in front of this court is domestic violence, it probably is aggravated by drugs and alcohol. Counsel, I feel like you've brought me an impossible situation unless I just order the police to go out, pick him up, put him in jail, and let him serve 6 months. I feel like I have been manipulated to the utmost in this case, and that's not like either one of you two to do that to me.
And Judge, I guess I take offense to the word manipulation. These are standard plea negotiations that I've entered into with the state. So yes, have we entered into a plea negotiation that was to leave out information from the court? Yeah, that's just standard plea negotiations, and that the court has on its own retrieve that information. Well, this is Your Honor, this is your court. I can't really stop the court from doing that since the witnesses are right here. But I think it is a plea negotiation that was warranted and well thought out, and one that we presented to the court.
Well, and I appreciate your offense, Mr. Patterson, but here's why I see it as manipulation. You weren't going to tell me that he was having contact with this victim of abuse. You weren't going to tell me that he was screaming and yelling at her to the point that a citizen called law enforcement and law enforcement came. You weren't going to tell me that he was seen driving while his license was suspended, which is a violation of the law. Bond says don't violate the law. Bond says don't have contact with this woman. Then when I get to sentencing, you've got him signed up to go into an alcohol and drug treatment program that nobody told me about, but it would circumvent reporting to treatment. And what about that statute that says he has a mandatory 48 hours and a mandatory $200 fine, which I can waive if he does the BIP intervention? But He's not set to go into BIP right away. He's set to go into alcohol and drugs. That to me looks like manipulation so that he doesn't have to serve his sentence, that he doesn't have to have any consequence for violating bond, manipulation that he doesn't have to have any consequence for what happened in violation of the law while he was on bond. I mean, driving while suspended, that's a B misdemeanor, a crime. And I'm not supposed to know about any of this. Let's keep the judge from knowing this. Mr. Patterson, that to me looks like manipulation. Maybe it's not. Maybe you don't see it as that. And I respect you as an attorney, and I have for many years, and I respect Mr. Regier as an attorney. And I have for not as many years because he hadn't been at this as long. But this is highly troubling to me that I'm seeing this. And if this is standard, and I haven't seen it before, and I'm being duped by it, that's alarming. Because judges are supposed to know what they're dealing with when they make a sentence. And how's Mr. Branscombe going to deal with this? Again, this is outside of my jurisdiction, but at the same time, what he does in other jurisdictions should affect what he does in this court on probation or as such. But if he's facing driving while suspended charges, but he can't go because he's in treatment.
I don't know that he is, Judge. I haven't seen any charges filed in the city of Newton.
Fair enough, fair enough. And I know that if they need alcohol and drug treatment, that's a very big, important priority. Unless it's designed as manipulation to skirt consequences. Was there even an evaluation, or did I understand him to say he just went and signed up for it?
Judge, I can tell the court this was the treatment program was not part of this case or part of the negotiations. That is something he's doing on his own. This is the first I've heard of it. The batter's intervention program, on the other hand, is something that was part of the plea negotiations.
Mr. Branscombe.
Yes, Your Honor. I just want to say that I did get a evaluation. Actually, I got several of them over this last about week and a half to try to find the earliest opening bed that I could so I can get into treatment sooner than later. And the one that I found was supposed to be today at 9 o'clock in the morning. I had court at 9, so they extended it till 1. But I have another. They said that it would be okay if I came in tomorrow. If it doesn't work, they told me to give the judge their contact info and that she can contact and talk to you and tell you about how I came about getting there and everything else. I'm not trying to manipulate you, Your Honor.
Mr. Branscombe, this allegedly occurred April 16th. Well, this did occur because we found you guilty. April 16th, 2025. What motivated you between then and today, June 9th, 2025, to go out and get this evaluation?
Well, the loss of my children that were taken from me and my wife not being able to have contact with each other.
But you have been having contact.
I have. I'm not going to completely lie to you, Your Honor, but it hasn't been like it was. Like we're a family. We live together. We're with each other every day. We're a family. We have a business together, and it's gone from all of that to, and all of a sudden, in one waking moment, my children were taken away. I wasn't allowed to be told where they were. My wife I was told I couldn't have contact with her. So there goes my work because I don't have a valid license. She was the one who drove us, and she was my helping hand in our business. I mean, we have a LLC. We've been open for 3 years, and it's just all of these things were just all at one time. And I just came to the realization that, when we were clean for 7 months just recently, we got off the drugs and we were clean for 7 months. We didn't argue one time, Your Honor, like not one fight. I mean, nothing. And it was awesome. It was amazing. And then we relapsed, and things got worse and worse and worse, and I recognize what it is, and I know that I can't get my family back without me getting myself clean. and it's been on my heart and my mind, and I've been thinking about it over the last month and a half, 2 months, and it's time. I want my kids back. I want my family back.
Did you make this appointment after you had contact in Newton with law enforcement?
Yes, Your Honor.
So it wasn't the domestic violence in this case that was the final trigger to make him do the appointment. It was the second contact.
Yes, it's just that it wasn't
All
the
right.
domestic.
It wasn't the domestic. Go ahead.
It wasn't the domestic per se. It was just me coming to the realization my family's been torn apart and being held away from me, and it's all due to my usage and being an addict, and I wanted to get it fixed and then get it right. I don't want to lose my wife and my kids.
Well, you're saying all the right things.
I mean,
Okay. When's your next available bed?
today
What time?
it was at 9 o'clock, but they said they can push me out until 1 o'clock
1
for them
o'clock.
today. Yes, ma'am. And if I can't get in there by 1 o'clock, that they want to be able to get me in through the rest of the day. That tomorrow morning to be there at 8.
This is alcohol and drug treatment. What was the facility?
It's Cherry Creek.
Cherry Creek. Okay. And it's in Newton?
No, this is in Wichita.
And it is inpatient for how long?
I believe it's a 30-day program.
You don't know?
I haven't got all the fine details. I mean, they sent me the
were gonna-
pamphlet.
You were
I'm
going to
sorry.
go check into this facility without even asking them how long the program was?
I need it, ma'am. I mean, if it's 30 days, 60 days, it really don't mean a lot of difference to me as long as I'm getting what I need to and getting some clean time back under my belt and getting back out here for my family.
Well, I cannot tell you how many times I have seen someone who gets into your position use treatment as a hiding, as a manipulation, as a way to avoid consequences. Whether
Yes.
you're doing that or not, I don't know. You sound, like I said, you're saying all the right sounds or words. You've got the right inflections. I am going to withhold your sentencing until you complete your treatment, but it better be inpatient.
Yes, Your Honor.
And you contact the attorney as soon as you get close to your out date.
Yes, Your Honor.
And I'm going to get you right back in here as soon as possible for your
Yes, Your Honor.
sentencing.
Yes, Your Honor. Thank you.
Is everyone clear on that? We'll
And Judge,
continue.
I guess what I'd ask him to do is when he goes to the treatment facility, that he have them send me a report stating he's admitted and what his out date will be. That way we know a little bit sooner than just when he's released.
Yes, do that because Mr. Patterson, and if you'll get that to me, I'm going to set the hearing in relation to when the out date is set to be so that I don't just drop the ball waiting for him to contact us because we know that would not be a wise decision.
Yes, Judge.
But but in the meantime, I'm still going to set a date, just a control date, Mr. Patterson, but I want to change it. What do we have, Jen, about 30 days out?
One moment, Your Honor, I'll look.
Okay. And it could be that if it's a 30-day treatment program, we may end up getting lucky and setting it now, and why isn't the victim here, Mr. Regier? Did she have notice of this hearing?
One moment, Your Honor.
I'm going to, Officer Sovcit, Ms. Slater, you are welcome to stay to the outcome, or you're welcome to go. We've used so much of your time this morning. I want to thank you for being here. I want to apologize that you've had to wait so long. But I'm going to leave it up to you if you want to stay or go.
Thank you.
You're welcome. Thank you.
Your Honor, the state's information is that there has been contact between the victim and my office as recently as within the last 2 to 3 weeks.
Well, make sure she's given notice of this fall next hearing. It would be helpful to hear from her. Okay, Jen, did you find a date about 30 days out?
Wait a minute. We have some room on July 7th or July 21st.
Let's see. Let's go with July 7. That's closer to the 30-day mark. July 7, 9 a.m. This matter is continued for sentencing unless, Mr. Patterson, you find out something closer. I don't want him out before I see him again. I don't want him, but you are still on bonds. You are not to have any contact with her, Mr. Branscombe. You are not to violate any laws. You're muted, sir.
Yes, Your Honor, I understand.
All right. Anything further from anyone?
No, Your Honor.
Not from the state, Your Honor.
Thank you. Get to treatment. You better be there at 1 o'clock or it's a violation of your bond.
Yes, ma'am.
All right. And get proof to your attorney.